Well, good afternoon, everyone, and I am sorry I am late to the party. Obviously, many of you have heard, if you have been living under a rock for the last 30 minutes or so, Carmelo Anthony has been found guilty as charged of murder in Collins County, Texas. We're going to talk about that a little bit. I have some interactions with y'all in a little bit. Thanks for everyone who's tuning in. I appreciate it. We are Washington Gun Law. We're going to not really tell you so much how to think, but we are going to give you all this stuff to think about. We're going to be going over some stuff today. I am going to be relying again on NBC DFW Channel 5 and down there in Dallas, Fort Worth. The only reason because they have seemingly not done me wrong yet. Did not know how the sentencing phase necessarily works in Collins County, Texas, but apparently, if this case had happened in my jurisdiction where I predominantly practice, King County, Washington, the defendant would have been remanded into custody. We probably would have set a sentencing hearing out about 2 weeks. They would have remained in jail, would have been pre-sentence reports and all of that stuff done. We come back for sentencing at a later date, obviously racking up credit for time served for all the time he's spending in there between time of conviction and time of sentence. What they do here in Collins County, Texas, maybe this is the way they do it throughout the whole state of Texas. So if we got a Texas state attorney on there and knows what they're talking about, drop something down there in the description box. Emily Taylor, are you out there from Armed Attorneys? Drop something down there and let us know. So anyways, but here's what I want to go back and talk to you about what was reported 35 minutes ago. The same jury who has found him guilty, they deliberated less than 3 hours. So I want you to understand that for a charge of this magnitude, in this case, I can't believe the lightning speed that this case moved at. This case was tried. This is day 5 of the trial, but a couple of days were really spent just selecting a jury. Okay, so this thing was really tried in about 4 days. It's pretty remarkable. But you're talking about a very, very not necessarily complicated case, but a very serious case. And so for a jury to take less than 3 hours to deliberate, and we had talked about you with the live show we did this morning, that sometimes when you're trying a case, depending on what your theory is, depending on what table you're sitting at, a quick verdict is either good for you or bad for you. And in this case, as I read the tea leaves, I felt that a quick verdict would be bad, especially when you had when the jury was given an opportunity to have a lesser included of manslaughter in there. The fact that it came back so quick, I wasn't worried about the jury just trying to split the baby and necessarily go with the lower one, because that would have led to, if there would have been some jurors who had thought manslaughter was more appropriate, we probably would have ended up with much longer deliberation. So it tells me that they really kind of, there wasn't a lot of arm twisting, there wasn't a lot of convincing, there wasn't a lot of tug of war going on, and that this was that was pretty united, probably from the get-go. Again, we'll find out later if the jurors are willing to talk, if the jurors even want to talk. I can understand why, if you were a juror on that case, you might want to change your name and move to another county or something like that. I mean, this could be a very volatile situation. The same jury will now decide whether Carmelo Anthony's sentence will decide the sentence. So the jury sentences in Texas, which is interesting, but probably not unique to the state of Texas. Again, in Washington State, many states, the judge would actually do the sentencing. In Washington State, we have a thing called the Sentencing Reform Act. So there would literally be an offense level for this case, as well as his criminal history, which would be a 0 at this point. There would be a box that the judge would find. It'd be a low end and a high end range, and the judge just got a sentence somewhere in the middle of that. And it's not anywhere from what this kid is looking for, which is anywhere 5 to 99 years. During the sentencing phase, the defense can argue that the murder was committed under the immediate influence of sudden passion. Prosecutor Dewey Mitchell mentioned sudden passion during voir dire and explained that it was a situation when someone is in such a state of emotion based on something that just happened that they don't have time to cool off. If the jury agrees, I want you to listen to this. This is a very interesting thing where this is then proven post-conviction or alleged by the defense, and if the jury agrees with what is called sudden passion. And this is why in some states you have premeditated murder or aggravated murder, okay? Because aggravated murder, there's oftentimes these crimes of passion and things like that fall under the aggravated murders, no opportunity to premeditate, no opportunity to cool down. Whether or not you think that's a legitimate defense, you are absolutely entitled to your opinion on that, okay? But this is how it works in Texas. This is how it works in a lot of states. The the ability to be sentenced to something less. How it's being proven and how it's when it's being argued. Again, in Washington State, it would have to be briefed. You'd have to notify the other side that you're going to do it, and then it would be an argument in front of the judge who ultimately decides the sentence. Here, the jury is going to decide it. If the jury agrees, the charge is reduced to a second degree felony, which would lower the punishment range from to 2 to 20 years. All right. It also says in here Carmelo Anthony remained emotionless when the verdict was read. He was escorted out shortly thereafter. Now, I know some of you are going to try to read into this kid's cold-blooded killer. She showed no emotion. Understand that it's entirely possible that his defense attorney knew what was coming and had already prepared the kid for this. He may have had some emotional outbursts privately because he knew this was coming, but whatever, that is what it is. Okay. Now, apparently 20 minutes ago, the sentencing phase begins. Anthony's mother has been called to the stand. Kayla Hayes, Carmelo's mother, was called to the stand. Mike Howard offered her water and tissues. He's my oldest, she said. He'll always be my baby. I love him very much. She was obviously very emotional during it. Do you believe that Mal regrets what he did? Yes, I know my son. He's very sorry for what he did. Is there anything you want to tell the jury? And her answer was, please have mercy on my son. You love your son and you realize you're still going to be part of his life. Howard asked, yes, I do. And the defense rested moments later. So, again, I'm not going to critique the effectiveness of this type of testimony because I'm not that familiar with this very unique sentencing phase that they have in Texas. And now the court is on recess. Currently, large crowd appears to be gathering outside the courthouse. I'm sure there's plenty of other things out there on other social media platforms that will probably have a lot more information as to activities which may be occurring outside the courthouse or around the country. Okay. Interested to hear what all of you think. I have tried to keep my opinion out of it. I've tried to explain everything according to the law, and we're going to try to continue with that mission. I know many of you have very strong opinions, and I appreciate where all are coming from. So, at the end of the day, I believe that this was the correct verdict. I believe that there is a reason that this case was tried in a very short period of time. And I believe there's a reason that the jury did not take particularly long to deliberate to reach their verdict. Okay. And here's why I say that is because there was multiple different deficiencies in any type of self-defense argument here for Mr. Anthony. There was the disproportional force. There was the fact that he could have also been the agitator or what they call provocation in the state of Texas. And there was just so many different hurdles for which the defense was going to have to overcome. And it has nothing to do with the color of anybody's skin here, because if you took the skin colors and you reversed them between victim and defendant here, and the facts were the same, I'd be saying the exact same thing. Why? Because it is the application of that same set of facts to the acceptable and agreed upon law. That's what we do. That's when the criminal justice system is working correctly, this is what happens. Okay. And so I do not envy being in those jurors' position for multiple reasons. If they want their privacy, I think everyone should respect that. But you are laying in judgment of a very young man who committed a horrible act, and you are going to determine how much of his life does he spend behind bars. So this is a big deal. And then there's all the hoopla and all the other garbage that's going on with this thing, much of which has absolutely nothing to do with the merits of the case at all. But they're going to have to be dealing with that as well. So this is not a good position for if you were a Carmelo Anthony jury. I do not know if they are going to be taking any other testimony on this. I'm assuming that mom's testimony standing alone is not going to be able to prove the potential defense. For those of you who are just joining in, let me get you back up to speed on what happens here, because this is very unique, and this is going to be the last remaining loose end of the story related to the trial. What I'm worried about tonight is that we're going to have a lot of other stories related to the fallout from this trial, but has nothing to do with the merits of the case, has nothing to do with the actions of the court. I know there's going to be a lot of people trying to say a lot of things about the defense attorneys here. I've said it before multiple times. I'll say it again. difficult to make chicken salad out of chicken shit. And this case presented just not a good set of facts at all. And it just really wasn't. Okay. So the way they have already begun sentencing in Texas, the way it works is that the jury is now going to sit and pass sentence. Right now, Mr. Anthony is looking between 5 and 99 years, and the jury gets to decide that. Could you see a jury decide to show a little mercy on the fact that it's a young man with no criminal history? I suppose that because if they got a long range, I guess all I got to do is pick a number, right? Agree upon a number. However, in the state of Texas, there is a thing called sudden passion, which is you can argue that the murder was committed under the immediate influence of such. And it was apparently brought up during jury selection. So obviously, at least one side, and presumably if the other side was paying attention, would have realized that this is a potential post conviction strategy. So this probably is not a surprise to anyone. But if the jury were to find that it was done under sudden passion, which candidly, there is some evidence to suggest that, and there's some evidence that works quite way against it. The bringing of the knife all together, the putting your hand in the bag and asking him to go ahead and touch you or dare him or whatever it turned out to be there, those cut against it. Okay, those cut against it. The thing that works for it, of course, is that this did happen amazingly quick, and you're dealing with really young emotionally immature individuals. So, again, I'm just telling you what the law says. I'm not telling you how it's going to come out because we're going to find out, and it's not up to us anyways, is it? But if the jury were to find out that or determine that was committed as sudden passion, then they can reduce the charge to a second degree felony, and then the standard range is anywhere from 2 to 20 years. So, is there a possibility that Carmelo Anthony could be sentenced to merely 2 years in prison for what happened? Yes, that is a legal possibility. What is the legal probability of that? I don't even want to get into that guessing game. In order for it to occur, a jury would have to, one, find that it was committed as under the influence of sudden passion. And then number two, decide to sentence him to the lowest end of the range under that second degree felony, which is 2 years. So it's a bunch of if, you got to really thread the needle here. If a jury does not find sudden passion, then the least he could get, the minimum is 5 years. The maximum is 99. Candidly, if you're a jury and you're going to find sudden passion, you're probably thinking low numbers beyond that, because why would you give them 20 when you could have just given them on the original charge? I don't know. I'm sure a second degree felony still comes with all the hoopla and bad baggage that carries with it in a state like Texas, which means disqualified from possessing firearms for the rest of your life, probably disqualified for voting. Don't know how the restoration system works in the state of Texas on that. So that's where we are at. We got a new update. Let's see if it's anything actually worth updating you guys on. We got a statement from Jared Patterson, the Texas State Representative for District 106. The murder of Austin Metcalf was a senseless and heartbreaking tragedy that forever changed the lives of his family, friends, and community. Nothing can restore the life that was taken or ease the unimaginable pain of losing a child. Today's outcome of a murder conviction is justice served. I commend the prosecutors, witnesses, and jurors, each of whom participated in serving their community and rendering justice for Austin. While no outcome can erase this pain, it is our hope that this moment allows the Metcalf family and our community to begin the difficult process of healing and moving forward together. We continue to mourn Austin's loss and pray for healing for his family and those affected by this tragedy. And that again is from Texas State Representative for the District 106, Jared Patterson. I'm going to presume that is Representative Patterson's district, Republican out of District 106. And yeah, listen, if you are a person of faith, if you are a spiritual person, I do think you should pray for a lot of people here, because there are two families that have been destroyed, one of which has nobody to blame but themselves. And the other family has been absolutely demolished. And so, if you are a person of faith and spirit or spiritual in nature, and you want to say some prayers, I think there are some people who could probably use your help today. So I think part of that comment, I appreciate that. Okay, listen, I'm going to go ahead and start going through the comments. Now, listen, I like to put up questions, okay, because then it allows us to engage in a conversation. So if you're, a lot of you are spiking the football. I'm sure I haven't looked at the comments yet. I'm sure a lot of you are spiking the football right now. That's cool. Get to be you. Everyone gets to be themselves here at Washington Gun Law. But if we have questions as to other legal things, this would be the time to start dropping those down in the comment section. I really, you know what? I'm sorry I was late to the party. I was actually at a security gun club doing two meetings down there about stuff, and got back here. By the time I got back here, the verdict had already been announced, and I had to pop this thing together, and away we go. And that's the Mickey Mouse operation that Washington gun law is most of the time. All right, so with that in mind, what could possible appeal routes be taken? Excellent question. Excellent question. First of all, if there is an appeal, which there will be, why not? Okay. And by the way, in most states, and again, I'm not a Texas lawyer. Let's acknowledge my my limitations here. Okay. I am not a Texas lawyer. I'm licensed in the state of Washington. I have tried many, 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 many cases. The verdict. I have been on winning and losing sides. So um, there are multiple things that could be appealed here. But would the sentence be carried out pending appeal? Yes. There are certain types of cases where you can get what's called an appeal bond, which is okay. I know you sentenced me to X, but I'm going to stay out of custody pending appeal. You have to usually post the bond and things like that. Those are for like non murder type offenses. Okay, so I expect him to be remanded into custody today to begin his sentence, no matter what the appeal is. There are all sorts of things that could be appealed here. All right, so let's talk about it because I think it's a great question. And for those of you who just joined in, the verdict is Karmelo Anthony was found guilty as charged, and we are now moving into the sentencing phase. Okay, jury instructions is a very, very easy way for a criminal conviction to get flipped on appeal. Okay, because there's a lot of things that can get let into a jury trial that an appellate court can sit there and go, well, that's harmless error. I mean, yeah, there was 18 pieces of evidence that suggested one thing, and really only 17 of it were admissible. But that one piece that we let in, it's harmless error because you were buried with all the other evidence, anyways. That's like a very simplistic way of trying to explain to you harmless error. Okay, but when it comes to jury instructions, if there was some deficiency in the jury instruction, then no, that's never harmless error. Because if the jury was improperly instructed as to what the law meant and said, then how could that possibly be harmless? Now, here's how, and especially in criminal trials, here's how that gets avoided almost always. Okay. Because you rarely see a criminal appeal that is successful on a bad jury instruction. And it's this is that the state of Texas, and I know it because I've looked it up, and every other state does it too. They have what's called approved pattern jury instructions. All right. And in some states, it's the Bar Association that approves them. In Washington State, for example, it's the state Supreme Court that approves them. But there is some higher body with the judiciary or with the Bar Association that said, yes, these are the approved jury instructions. So when it comes to criminal laws, it's pretty simple to do because it is basically like to convict this person of the following crime, the prosecution must show beyond a reasonable doubt the following. And then it lists the elements that the act occurred in Collins County, Texas, that on the date in question, Carmelo Anthony intentionally caused the death of Austin Metcalf, and then right? And so those are approved instructions. And so if you're the trial judge, the last thing you're going to do, especially from the prosecution side, is offer up any kind of jury instructions that hasn't been already approved, right? So that could be appealed if there was some irregularities in the jury instructions. Could there be irregularities in jury selection that could uh, lead for an appeal? Yes, but they would have to be highly irregular irregularities in the jury selection process. So we did a video about that. It's linked up in the description box. I don't want to get too deep into that. We'll get way too far off base. Then if you have inadmissible evidence that was offered during the course of trial, exhibits that were admitted that shouldn't have been admitted, questions that were objected to, the objection was overruled, and the witness was allowed to answer those things. If the appellate court determines that it could have influenced the verdict, if it came in but an appellate court believes that it really didn't influence the verdict, then it can be what's called harmless error, which is like, yeah, you're right. He shouldn't have been able to ask that question, but big deal. You're going to lose anyways. And this there was a lot of evidence against Mr. Anthony here, so that could be a possibility. So those are the types of things that can be appealed. It's an excellent question. There will be an appeal. In general, every criminal defendant who's been convicted, even post jury trial, has the absolute right to one appeal. So, whatever the court is that sits above this court in the appellate court system of the state of Texas will take this appeal, and this case will be heard on the merits, guaranteed. If Mr. Anthony were to lose, or let's say there was a adverse ruling against the state of Texas, then the case either would come back down to the lower court for resentencing or a new trial, or depending on what happened, it could be appealed to a higher level. So, long way down the road there. All right. Um, so that is just a few things that you need to understand. And again, I expect an appeal because you get one appeal as a matter of right. What do you got to lose, right? What's the worst the appellate court is going to say? No. Yeah, all right. Well, you're already serving the sentence anyway. So appealing is, you know, depending on what the sentence of the court is, this kid may have a lot of time to file appeals. Let's see if we got a new update. Now, the last update we have is from it's just the statement from Jared Patterson, Texas State Representative, District 106. All right, let's see what else you guys got. All right, someone's saying 25 to 40 is the likely sentence. Well, we'll see. I'm not going to repeat that one. Um, does the Austin Metcalf family have a simple wrongful death case? Answer: yes, they do. Yes, they do. They actually could have had a civil wrongful death case even if Carmelo Anthony was found not guilty. And you're like, what? And I was like, yeah, you remember Ron Goldman's family successfully sued O.J. Simpson, right? So yeah, that can be, and of course the burden of proof at wrongful death because you're talking about intentional torts. You're talking about tort law now, not criminal law. So we're not even operating in proof beyond a reasonable doubt, nor are we even operating with unanimous juries. So preponderance of evidence, 8 out of 12 agree, you're the winner. I mean, that's how it works in some states with these civil cases. Now, here's the question: Is the Anthony family worth suing? Okay, because let's say you could go get a $5 million judgment against them. All right, great. If they don't have the money, how are you going to collect it? Oh, and you get into we put writs of execution and all that stuff on their assets, and then put liens and all that. Okay, yeah, and you recapture 5% of it or something? I mean, I don't know. So I don't know what their assets are. I don't even want to get into that. But the answer to the question is, do they have a wrongful death claim? Yeah, they've always had a wrongful death claim. They always have. Uh, all right. Let's see what we got. Put a lien on that new house. Yeah. All right. Oh, you guys are colorful today. I thank you for the colorful comments. But again, I I'm not here to spike the football here, guys. I really not. And I get that there's plenty of other content creators out there that are doing that right now, and that's cool, man. It's cool. Everyone gets to be who they're going to be. My job here, as I view this platform, is can we actually use real life examples to teach people how the law does or does not work? And sometimes the judicial system works really well, and sometimes the judicial system doesn't work well. And there's a lot of reasons why it doesn't work well. Sometimes it has to do with ineptitude, incompetence, laziness, political motivation. There's a lot of reasons. But then occasionally we have cases where you take a look at this case. Okay, this case. I think everyone here has a very strong opinion here about what the right verdict is. And so most of you are satisfied with today's verdict. This case was tried in a very short period of time. It was not a big media circus. Judge kept that stuff out of the courtroom. I know we like to have a little bit of transparency. I get that. But this case was tried in like a week, including with jury selection, and the jury deliberated for like less than 3 hours. I mean, that is streamlined justice right there. All right. And you didn't even see the defense attorney dragging this thing out. So occasionally bad, terrible things happen that the criminal justice system has to get involved in. And occasionally, the criminal justice system works exactly the way it was designed to work. And this appears to be one of those situations. Okay. Uh, Sean Connolly says most cases are like this. I believe that he is right to a large degree. I believe that depending on what state we're talking about, what county within that state, you see different criminal justice systems much more efficient than others. You see some that are much more well funded, well staffed than others. And there is definitely an attitude about criminal justice that differentiates around the country. Okay. Because, like Sean Connolly, who made a really good statement there, if he came on up to King County, Washington, and saw our criminal justice system here in downtown Seattle at work, he'd be like, is everything like that? And I'd be like, yeah, everything's like that around here. So, and maybe down there in that Connor County, Texas, I believe is what it was. Maybe that's exactly the way it works. And okay, cool. You guys got a much more efficient criminal justice system down there. So, anyways, somebody did also mention that the Batson challenges could be an issue. I don't know if there were actually Batson challenges made during jury selection. I'd have to dig more into it, but well, a good thought out question, because a Batson challenge is this, is that you get to strike any juror for cause. So if you had a juror who just simply said, yeah, I could never find the kid guilty because of A, B, and C, and they just flat out said that they have a bias, they can't avoid that bias, they cannot follow the court's instructions, they cannot follow the evidence, then you can challenge them for cause. And just like the same thing, if you're the defense attorney and a juror comes out and says, he's guilty of sin. I don't even know why we're having this trial. Okay, you're entitled to that opinion. You're just not entitled to be on that jury. Okay, because again, you demonstrated a bias and you cannot follow the court's order. So both sides get the challenge. And if you had 20 jurors like that, you could use 20 challenges against jurors. All right. But understand that when you are challenging a person for cause, you literally have to put on the record what the cause is. And it's through the questioning you ask. Okay. And you can do things like, for example, if years and years and years ago, if I was trying a vehicular homicide case where a drunk driver had, gone out and committed, caused an accident, killed people. Okay. And now I got number 17 over there whose brother was killed by a drunk driver 10 years ago. You just ask her, like, that must have been horrible. I mean, my God, you probably still, how can you ever get over something like that? Right. And then it's like, I don't even understand how you could even think about being fair or impartial in a case like this. This has to infuriate you. Do you agree with that? And they'll always look, yeah, okay. Now I get to challenge that juror for cause, and I appreciate her honesty. I feel terrible for what she had to go through, but now I can challenge her for cause because she just flat out said she can't divorce herself from those biases. And I think it's a reasonable, very believable answer. All right. So you can do that as much. And nobody gives two what's about the color of the skin of that juror when you got a reason to do it for cause. And the prosecutor gets to do it also. All right. So if you had an African American juror sitting there who says, I could never find a young African American male guilty of a crime like this. Hypothetically, I'm not saying that happened. I'm using this as an educational opportunity here. Okay. Then a prosecutor could flat out challenge that juror for cause. And again, it has nothing to do with the color of their skin and everything to do with what just came out of their mouth, which was an expression of what their bias was and ability to follow the court's instructions. Okay. So you don't really get the challenge for I mean, could you appeal a judge determining that, yeah, that juror is successfully challenged for cause? I suppose you could. Again, what's going to happen there? Now, you get this other thing called preemptory strikes, where you get to strike them for any old reason you want. Okay. And there were times where I would strike jurors just because I didn't like the way they were giving me or my client the evil eye during voir dire. I just didn't like them. Sometimes they'll fill out these questionnaires ahead of time. You get these questionnaires filled out, and it tells you a whole bunch about them. And if you actually read them, you might be like, ugh, that's exactly the opposite of the type of person I want on this jury. So I'll strike them. I won't even waste any time. I only got 25 minutes to do this. I'm not going to ask them any questions. I know what's happening to them already. So they're going to go. But if my strategy in using my preemptory challenges are, I'm going to get rid of all the African Americans on this jury. Okay. And the other side alleges that I'm doing so, then under a case called Kentucky v. Batson, you have to, if I'm the side proposing the strike, I have to place on the record some reason beyond those protected reasons for which I am excusing this juror. And any plausible answer will do, but I'm going to have a plausible answer. And the court determines whether or not the Batson's challenge from the other side is sustained or overruled. If it's overruled, juror goes. If it's sustained, okay, there it goes. So the notion that you could just go in and start cherry picking a jury on race is it's not doable. It's just not do if the other side is doing their job, it's just not doable unless there is a real homogenized jury pool, right? If you have 75 potential jurors, of which you're going to pick 12 jurors and 4 alternates, and of the 75, 6 of them are African American and everyone else is Caucasian. Okay, remember, it is a jury pool that is created out of that geographic region, out of that county. So jury pools have a tendency to oftentimes, shockingly, reflect the area of where the trial is occurring. And in King County, like when I tried cases inside this county, okay, with the district court level, right, there was difference between a juror that was in Redmond, Washington, and a juror that was in Seattle, Washington. Okay, there was a difference in it, and when you move from county to county and get further out, and in a state the size of Texas, you can imagine how diverse the jury pools would be in that state, depending on where you were in that state. All right, and jurors are randomly selected. Every state has a way in which they select them. They are randomly selected. Many of you probably have been stuck on jury duty. I should do a video one time about how to get off of jury duty. It's pretty easy. I will say this, the live feed that I'm watching on NBC DFW, Channel 5 in Dallas is, it does look like the crowd is gotten smaller, and I will say that I don't know what's going on out there on X, you guys can tell me, but it does not appear that things are getting out of hand there. I do not have any updates as to what's going on in the sentencing phase. It is 3:38 back there. The last update I have is from 3:12 PM, and it was again, the statement from, Texas Representative Jared Patterson. All right, let's see if we got some other questions. Man, you guys. Can I do a backflip on the camera? I can't do a backflip on the camera or off the camera. I'm gonna be 57 later this month. My backflip days are over, but thanks for asking, I appreciate it. Oh, guys, very, very colorful comments. There's a reason I don't put them all up on the screen, but like I say, hey, welcome to Washington Gun Law. You get to be you. God bless all of you for supporting the channel. I appreciate it. All right. For those of you who are joining us late, Mr. Anthony has been found guilty as charged of murder. They have already moved to the sentencing phase, which in the state of Texas is handled by the jury. Only one witness has testified so far. That was Mr. Anthony's mother. There was nothing substantive to the testimony. I'm not being critical of Miss Anthony. It was exactly what you would expect a loving mother to say. So, um, this is a bad day for Carmelo's mom. I think everyone needs to recognize that. Now, um, they are apparently on recess. I do not have any other updates. But what you need to understand is right now, if he's sentenced under what he was charged as, or the jury theoretically has found him guilty of, he's looking anywhere from 5 to 99 years. Huge range. Jury is going to decide. However, if the jury believes that this crime was committed under what Texas calls sudden passion, they can reduce the crime. The jury can reduce the charge down to a second degree felony, and at that point, the standard range goes from 5 to 99 down to 2 to 20. So, is it possible that Mr. Anthony could actually be sentenced to a mere 2 years incarceration for this? Yes, it is possible. How probable that is, I'm not going to get into that. If I had to, I would say it's not very probable. It's going to require a lot of things to line up just right. And so far, nothing has lined up right for the defense in this case. And again, I am not being critical of the defense attorneys. I know a lot of people are. I just, man, unless you have information on the inside game, you just don't know what's going on. And this was a case that just did not present a lot of good evidence. If 10 years in jail doesn't convince this guy he did a dumb thing as it should, then it will do nothing. Well, I mean, I don't know. Let me ask you guys this. Not that any of this is going to matter, but if you were sitting on that jury What would you sentence this kid to? I'm interested. There's no right or wrong answer. All right. And would you find that this was committed as a sudden passion or whatever the terminology there was in Texas? Let me pull it up again. Was it, Texas, man, they do things their own way down there. God bless them. Um, but they definitely do things a little different down there. So, all right. Yeah. Sudden passion. That's the exact legal term. Would you find that this crime was committed under sudden passion? Yes or no? And then after you tell me yes or no, give me the number. I'll put that up on the screen. That I will put up on the screen, guys. I'm not gonna, gals. I'm not gonna put up some of this other stuff because hey, try to make this a family program here a little bit, right? All right. Here's what I got. All right. Here we go. Do this. All right. We got guilty life. Okay, that would be 99 years. Okay, for those of you death and firing squad, that's not on the table. So thanks, but that's not on the table. No sudden passion, 99 years. 50 to 70, parolable after 35. Life, I'm going to assume that's 99. Guilty with life. Someone says no, 10 years. Someone says 45 to life. Okay, again, I get the one. I get some of you are huge fans of capital punishment. And yes, the state of Texas is pretty good at it. Okay, they are. A lot of people think they're the king of it. I will give you an interesting stat here. I'm going to write it down right now because I remember it. But if I keep talking, it's going to be, I'm not going to remember it. All right, no, 25 to life. So no sudden passion, 25. I got that from 2 consecutive people. No. He got 600K and picked the public defender. He may have gotten 600K. The attorney was not a public defender. I already did a video on that. It's not. No, 50 years, 40 years to life. So I'm going to assume that's a no. Okay. Well, I don't even think if we executed them that way, that was how they would do it in Texas. So I'm not doing that. Life, 50 years, 80 years, no parole, no sudden. Okay, so no on the mitigating factor, if you would. 25 years minimum, no 20 years, 99 years with a whole bunch of exclamation points. Oh, you guys are great. Okay, 25 to life. I see 15. I want to find somebody down here at the low end because I get a lot of you here are 99, 50, 99, no 35 years, no sudden passion, 30 to 50 years, no 99. All right. I appreciate this because this is different. It's J-Rod. J-Rod 4252. He goes 15. That's the low end. And if J-Rod, if you want to explain, and listen, I am not being critical of that comment. I am not. I actually, because so many other people are weighing in on one way, if I ask why, I'm going to get a lot of the same answers. Your answer is at the other end of the spectrum. And you may have very good reasons for it. If I was a defense attorney right now, I am a defense attorney. If I had to do this, I could come up with some plausible arguments. Would they be persuasive? Well, we'd find out, wouldn't we? Okay, so if you want to put another comment down, and if I catch it, man, I'd love to see. I'd love to hear your thoughts. I appreciate you tuning in too, brother. By the way, 25 to life, realistically, 50 years. Give the GoFundMe to the Metcalfs. All right. All right. A lot of you guys, again, a lot of proponents of capital punishment here. I appreciate that. We're just not. We're just not talking about legal impossibilities. Okay. No. Again, I'm putting up some that are Jace's mommy. No, 15 to 25. All right. Oh, hey, someone does point out. Hey, just so you know, here, guys, right. In Texas, the only option for death penalty is the needle. Okay, that's how they do it in Texas. You guys want to know how we used to do it in Washington before we put a moratorium on it? This is no joke. You can look it up. We actually only did the last one by lethal injection. The 3 we did before that, before our state kind of went different politically, and we just don't do that anymore, is we did it at the end of a rope. I'm not joking. The last 2 people, I remember both of them. One was a guy named Wesley Allen Dodd, and the other one was a guy named Charles Campbell. And we had gallows down at Walla Walla State Prison over in Eastern Washington, and that's how we did it. So we don't use it anymore there. Okay, This is at Laura AC, 25 years with parole eligible at 12 and a half, which I'm assuming is halfway through it. Okay. Uh, I I'd like to hear your justification. I'm not saying you're wrong. I want you, and if you don't want to do it, I get it because you don't want to become like the subject of this conversation. I just because I got 90% of the comments all saying 50 and above, and I got about 10% of them asking for a penalty that can't even be carried out in this case. I would really like to hear your thoughts on it. So, by the way, for all of you tuning in right now, appreciate it. If you're late to the party, hey, that's cool. So was I. Washington gun law. We usually cover Second Amendment litigation, Second Amendment legislation. We talk about self defense cases. And we try to use real life examples to do education. This is an opportunity to actually educate you guys about the trial process and things like that. We're talking about the sentencing phase now. Mr. Anthony was found guilty as charged of murder. The jury is now engaged in the sentencing phase. We have a new update. Let's see if it has anything worth updating you about. Oh boy. So, shortly after 3:30, that'd be about 17 minutes ago, Carmelo Anthony returned to the courtroom. According to NBC5's reporter who was inside the courthouse, Anthony was physically shaking and being held by a female defense attorney. Judge John Roach was informed that the state agreed to the addition of sudden passion as the jury continues with the sentencing phase, meaning that the defense can argue that the murder was committed when the defendant was in an intense emotional state triggered by immediate provocation from the victim. Okay, all right. During voir dire, prosecutor Dewey Mitchell explained that sudden passion is a situation when someone is in a state of emotion based on something that just happened that they don't have time to cool off. If the jury agrees with the sudden passion argument, the charge is reduced, and it goes through what I've already guys told you about. Now, what else? The jury will be brought back into for what amounts to a mini trial with opening statements from the prosecution and the defense. Here we go. A video will be played for the jury about sudden passion, probably just merely uses the language that is in the actual Texas statute. All right. After which they will deliberate and decide on punishment. Mr. Anthony has chosen not to testify in this section of the trial as well. Okay. Well, there you have it. So it is going to the jury as a crime. Well, for the jury to determine if it was a crime of sudden passion. Okay. It will be for the jury to decide. The prosecution has agreed that it can go back to the jury. That's obviously what this delay was about. It was obviously defense counsel and state's attorney in chambers with the judge talking about it, negotiating it, arguing about it, whatever they needed to do. Okay. Whatever they needed to do. Um, it is a huge break, an opportunity for Mr. Anthony. Whether it's going to play out or not, that remains to be seen. Um, I don't know how much longer the jury is going to. Apparently, they're going to be brought back out. We're going to have opening and closing arguments. I don't know. With it being almost 4 o'clock now, back there in Texas where this is taking place. I'm wondering whether or not they're even going to continue today, or candidly, if I were the judge, I know this is going into tomorrow anyways. I'd probably excuse. It's been a long day for everybody. If I were the judge, I'd probably excuse the jury for the day. They actually probably need to be sequestered, but they're going to be sequestered tonight anyway. So we're just going to start a little early. Tell everyone to go get a good night's sleep, and then we come back and we start fresh again on sentencing. Um, so apparently, at some point, we're going to have statements, arguments by the prosecutor and the defense attorney, and then I'm assuming that there's going to be evidence put on. Or, I mean, I doubt we're just going to be doing it by oral argument, just eliciting facts that have never been put onto the record anywhere. So, um, anyways, that is what's happening. Um, why didn't this is a good question. This is a really good question. Why didn't Carmelo take the stand in his defense? He was all about defending himself that day. All right. It is in criminal trials, uh, it is rare that you will put your client on the stand for many, many, many reasons. One of them is, to be honest, that a lot of them happen to be guilty of something, whether they can prove it or not, right? But you got to understand that in this case, couple things. If you think you're gonna lose the case and you put your client up on the stand, you might actually get a three-word verdict rather than the one-word verdict of guilty. You get the three-word verdict of really, really guilty. But I have seen defendants do that and then kind of know that they got to throw a Hail Mary pass. So they get really creative with their testimony and they just get blown up on it. And then it's sentencing, the judge takes it out on them for that too. So you got a young kid, you got an 18-year-old kid, the emotion is crazy high. You got the victim's family sitting there, you got your own family sitting. I mean, my God, think about that. And so, and then, let's be honest, the evidence as it came in this trial was very one-sided, wasn't it? It really was. And so you put them on the stand just to hear them talk. If you can't even, it's not going to carry the day. So now, we've seen other self-defense. Kyle Rittenhouse did testify. Kyle Rittenhouse also had a plausible and viable defense. So that could have been one of the big reasons they had Mr. Rittenhouse testify, right? It worked, right? I actually thought his testimony was fairly effective. And obviously, the verdict was what I believe was the right verdict in that case. So I believe, again, not that my opinion matters, because we try not to do it here, but I believe that the jury, especially based on the evidence as I understood it to have come in, made the right call. And I understand why they made the right call in a relatively short period of time, because a 3 hour or less than 3 hour deliberation is incredibly, incredibly short for a case of this magnitude. Um, okay, so at this point, here's what I'm going to do. I'm going to stay on here for just a few more minutes, see if we get another update. Not, I do got to check out for the night. There's no way they're going to get to a verdict on this tonight. It's almost 4 o'clock. I don't know. Maybe somebody has some inside information on how Collin County Courthouse works, and are they? I mean, shit, these guys did go on a Saturday, so I don't know. Is the judge willing to be like, "We want to stay here all damn night"? I had to try a case one time out in Jefferson County, Washington, for any of my hometown crowd that's watching. That's a long freaking way from the Seattle area. And it was a case we finished trying the damn thing at like 4:30 in the afternoon. And so I was like, "Oh, I'm just gonna have to get a hotel up here." And the judge was like, "Nope, nope, nope. We're gonna stay here all night. Jury's gonna reach a verdict no matter what." And I'm like, "You gotta be kidding me." And we actually got a verdict at 9:30 at night. So, oh, by the way, I lost that case too. So I just want you to know that there are some trial lawyers who will only tell you about times they won cases. I can tell you a lot of cool stories, but I lost that one, and it was a bullshit loss. So I still remember the client's name. I'm not going to tell you, but all right. So I'm going to see if we're going to actually end up with. Listen, some of you guys talking about life in prison. Yeah, come on, guys. Let's be cool here. All right. So I'm going to give it a couple more minutes. But again, for those of you who just joined in or are trying to get up to speed on what's happening, the prosecutor has agreed that the defense can argue that this was a crime committed in sudden passion, that a provocation occurred, and that he didn't have an opportunity to cool himself off. And that would allow the jury to knock this down to a second-degree felony. His range would go from 5 to 99 years down to 2 to 20. So is it possible that he could get as little as 2 years? Yes. Did it become slightly more probable a few minutes ago? Yeah, it actually did. Why? Because now we know that it will be submitted to the jury for that purpose. Okay, which means that is one of the several things that needs to occur for this to happen to Mr. Anthony. Whether that's going to happen today or later, I have no idea. Listen, I'm going to go ahead and check out, and I don't know if I'll be back on this thing tonight, simply because I have to do a pre-recorded interview in 2 hours, and it's a really important interview for a new series that we're going to be starting later in the week or probably next week. And I'm really excited, but I can't really say anything about it right now. So for all of you who tuned in, once again, Karmelo Anthony found guilty as charged. Case is being submitted to the jury now under the sudden passion defense, which means a jury could, as a mitigating factor, find it to be a second-degree felony instead of presumably a first-degree felony. And standard range goes from 5 to 99 down to 2 to 20. Prosecutor and defense attorney both are making opening statements. I don't understand how, even if they did this, even if they get rolling today, I candidly don't see how they're going to wrap this up unless the judge goes. So if I get done with my interview and it's all of a sudden like 8 o'clock back in Texas and they're still rolling on this thing, I probably will get back on air and do something. But for all of you who tuned in, thank you very much. For all of you who regularly support Washington gun law, God bless you. Thank you very much for all your support. I appreciate it. Stay safe, and we'll check back with you in a bit. Thanks for watching.